Welcome to the D. Brooks School of Law Training Manual video. In today's video, we're going to go over a couple of items that help Mr. Brooks. Now, we also have some video footage of Mr. Brooks in his own court case that you are going to find to be critical in your court cases. So we recommend you watch this entire video all the way through to the end. Now, Mr. Brooks does not guarantee that these activities, these items, anything mentioned in the Darrell Brooks School of Law is going to get you off your charges, okay? What he does say is this is going to give you one heck of a chance. But you know what? In life, isn't that how it goes? We kind of all have chances. Before we get started, Mr. Brooks did have a message for all of you.
Ladies and gentlemen, I don't think it's fair to just say guys, but it took a lot of courage and a lot of guts to pause your life for this. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. Hopefully we got a lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind. Thank you.
Now, the first thing you're going to need before anything else is that Sovereign Citizens Handbook. I don't know where you're going to get it, but you need to get one. Now, they might have them online. They might, if you're already in prison, you might can find one from somebody there that's already next to, maybe a cellmate or somebody that's not giving you a hard time there in prison. If you have friends in prison, they might have one. Okay. So yeah. So let's start with our checklist. Now, Mr. Brooks does say that we should utilize all the items that the court provides for us. And you know what, people? These items are free. They're free of charge. So let's go through a couple of them. Now, Mr. Brooks, his court trial was in 2022. And as you guys know, COVID-19 was effective in 2020 when they shut down most of the United States. Most of the nation for COVID. So what Mr. Brooks recommends that y'all do is go ahead and utilize that mask. I mean, go ahead and wear that mask. I mean, here's the thing. If you have shame because you're in the situation that you're in, that's just fine. But people are going to be taking all kinds of pictures of you. You might even be on video. So what we say y'all need to do is go ahead and put that mask on. It's going to help you. It's going to help you in the long run. And two, there might be some witnesses that come up that can't even recognize you because you got that mask on. Now, they might tell you take it off from time to time, but we're going to show you how to take it off and put it right back on. So y'all can watch this video right here and see that.
When he came out from the garage, he was asking if I could call him an Uber.
Okay. The person that you're describing for us, sir, do you see him present in the courtroom here?
He's sitting over there with the mask on and in the suit.
Okay, I'm going to ask the defendant be instructed to remove the mask.
Mr. Brooks, please remove your mask.
And if he would look at the witness, please, Your Honor, with his head down, it's not to assist him.
All right, Mr. Brooks, please look up and look at the witness. Look at the witness, please. Thank you.
Now, the other thing is the prison Bible. You want to make sure that you take a prison Bible with you to court at all times. It can just be sitting there on the desk. It needs to be visible. You want to make sure you turn the book sideways so that the side of it that says that it's a Bible is facing towards the jury. And you just want everybody to know that you're a Christian person, um, or think that you're a Christian, because it might help. It just might help you. So just if something comes up and like what you're waiting for a real long time, what you can do is you can just pretend you're reading it. Heck, you could read it if you want to. It don't matter. But if you want to read it, you can. But Mr. Brooks really thinks that it's essential. It's essential in your case. All right. The other thing we want to talk about is when we're utilizing all of the items that are in the courtroom and around us, one of the things that we want to talk about is how the guards handle you, how they utilize different types of mechanical items or restraints against you. Now, Mr. Brooks had, in his case, he had a shock device on his ankles. He tells me this all the time. So, I think where he thinks where he messed up was that by not telling the court that those anklets were going off on shock devices all the time throughout the court. He was just taking that pain. He was taking that pain in, and he wasn't telling nobody it was there. He waited till the end, towards the end of his trial. So what he thinks that y'all should do is just go ahead and every time they set that shock device off, you need to just jump at it and tell them, my ankle, my shocklet's going off. Now, if you don't have shocklets, or that's what we call them, shocklets. If you don't have a ankle device that's got electrical waves going through it to shock your body, then what you could do is you could just pretend that you do. And at the end, like say towards the end of the case, when things aren't going great, because it could be, because we don't make no guarantees here at the Darrell Brooks School of Law. But if your case is not going well and it doesn't look like you're going to be able to get off the charges, what we recommend that you do is state that those anklets, whether or not they are, state that they are shock devices. And you could throw a big fat tantrum in the courtroom and just go off. And we're going to show you right here how to do that. Okay? One moment.
Important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public, and that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
Why would that?
The record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So.
Well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles.
There was no shock device.
It was a shock device. I was told it was a shock device.
Mr. Brooks.
And
that's
it was
why
covered
I'm
up.
the record.
It was covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect your
of
ruling,
those
but it
as
should be noted.
Your
it should be
objection is
noted.
noted for the record.
It should be noted that I had a shock device on my ankles. That's fact.
It
It's
is
a
not
fact.
fact, sir.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to require about what's being put on my body. I was told that they were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The
All right,
public
Mr.
doesn't
Brooks,
deserve.
the
public deserves
you've
to
made
know.
a record,
The
and
public
it's
deserves
noted.
to know about
And-
things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this voltage.
It's absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photographs
Well, show
that
the
will be
where's
part
the
of the
photographs?
record,
Where's the photographs?
and they
You
will
just
be
said they would be
sealed
sealed. Why do they need to
from
be
public
sealed?
view
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the public?
I need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right, so
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today,
It-
but I need to move
I don't
on
want
to.
to be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table so it couldn't be shown.
That's not
why I had
right.
a chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else could be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your
Well,
characterization.
it's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I'm quite sure there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need
There's
to move on to
there's public in the
scheduling.
courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury. That's
Mr.
why I
Brooks,
can only move
I'm advising you.
here or here.
Mr.
That's
Brooks,
the
I'm
reason
advising
why.
you.
And I always had the chair right here. Everybody that came to this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why
any
did I have a
further,
black cloth
any
in front of
further
the table?
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold me
letting
in
move
contempt.
on
That's
to
okay.
scheduling.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me
All right,
then. Remove me
Attorney
then. It's
Basie.
not going to stop the fact that they need
All
to know
right,
that a shock device
he's
was on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll make the
That's
appropriate
fine.
findings.
Tell the truth, though, Your Honor. Tell the truth. I had a shackle.
Lieutenant.
I had a shock device
Captain,
on my
can I
ankles.
please see you? We're
So these are the quick tactics that we like to go through in part one here of the training manual. This is a really short class. We want to let y'all know that you're not alone. That there are many people out there that are in your situation, and they need Mr. Brooks to help them. At the end of the day, when you get to the point to where you feel like, again, you are losing, you're going to go to jail, and there ain't no way around it because you've tried everything in the book. What you do then is you continue to make excuses. Tell them you don't understand what's going on. The other thing, too, is to be combative. And we're going to talk about those two items in the next chapter of the manual. Just make sure that you watch the next video when it comes up so you'll know how to defend yourself as a sovereign citizen. You, too, can get off your charges.
The record in State versus Brooks appearances are as they were before. Mr. Brooks, if you interrupt me, I will mute you so that I can make an adequate record regarding.
Me anyway, Your Honor.
All right, he interrupted. I will mute him. I need to make a record of his removal.